Hey, good afternoon, everyone. We're gonna give folks our normal about 30 seconds or so here to make their way in the room. But thank you to those joining as always on time, and for those of you that have continued to join us throughout the Explore Emory series. So we're excited to have you all. Let's see, we've got a good number of folks already in, so we're gonna give probably about 15 seconds more or so just to let some others come into the room. Excellent. All right, I think we'll go ahead and get started. I know, as always, we'll have folks kind of come in a few minutes as they go through. I know everybody's busy with classes or with work, so we appreciate you all being able to join us for the session and come through. I'm going to start and just go through some brief remarks and intros. As always, if you joined us for the other series, you know who I am by now, but if you're joining us for the first time, my name's Anthony. I'm the director of admission here at the law school. We're excited to have you with our kind of wrap up event for this week of virtual events. You all are in for a real treat. We'll have one more event this evening with some of our alumni from the California area. So if you have any interest in working in California after graduation, or just kind of curious what that transition might look like going from Emory out to work on the West Coast, join us for that one at 7 p.m. It'll be a great conversation. We've got two great alumni who volunteered their time this evening to join us. It'll start at 7 p.m. tonight, so make sure you sign up for that. So look forward to seeing everybody there. I see a few familiar faces and names here in the crowd. So it was good to meet some of you at our events in DC and in New York last night. We're looking forward to meeting everybody in person on next Friday for our visiting day. So we're really excited. We're getting geared up. But I promise I'm going to shut up now. I know you all are probably sick of my emails and sick of my introductions here, but we appreciate you sticking through and getting through. I'll be in the background here. But today's session, you all are in for a real treat. We've got Professor Matt Lawrence, who will be joining us, one of our great professors here at Emory. So today you'll get a really good sense of, the faculty, the classroom environment, and kind of what law school has in store for you. So I'm just going to really briefly introduce Professor Lawrence. Professor Lawrence, feel free to add anything else. I unfortunately won't have time to go down the full CV here, but Professor Lawrence graduated with his bachelor's from Brown University, attended NYU for law school. After that, had extensive work and experience throughout a number of government organizations, including the DOJ, where he performed as a trial attorney and did a lot of work in defense of the ACA throughout the courts as well. Has also had some experience teaching. He came to us previously from Penn State Law before joining us here at Emory, and we are super lucky to have him within our health law field. Emory and Atlanta are great places to explore that a little bit further. So with that, like I said, I will be here to help you all and answer questions. One thing we're going to do with the class, you all should have received that case from an email from me. We're going to ask for 5 volunteers to kind of join us up here with the class and interact with the professor as he kind of goes through the case and works you through that. So if you'd like to volunteer and you want to raise your hand, you can raise your hand through that function, and we'll get you up as we start the lecture. But with that, I'm going to hand it off to Professor Lawrence, and he's going to take you through this case and answer your questions. So Professor Lawrence, it's all you.
All right, thanks very much, Anthony, and thank you all for joining. I think Anthony might not invite me back to do this next year because the case I sent around and we're going to talk about today is an ERISA case in the area of health law. And, health law is not a 1L subject. And within health law, ERISA is like famously one of the most frustrating and hard to understand areas of law. So not necessarily perfect, but as I hope you saw if you read the case, or as we'll talk about today, it winds up being really, really important. And also a great way to illustrate some key kind of law school concepts. I actually, I don't know how many of you had the chance to read. And normally, if I could see your faces, I would talk about that and and see how many of you looked like away or looked eager. So it's really helpful for me to know how many of you had the chance to read the case, and then maybe to have a few who did have the chance to read kind of help with working through questions and things like that with no judgment. So first, I'm going to ask. This is not volunteering to be called on, but if you had the chance to read through the case or at least kind of skim it, do you mind raising your hand in the little like raise hand area, just so I can get a sense of where we're at? Wow, good. That's amazing. So thank you all. And it looks like we're pushing close to pushing towards a majority, which is fantastic, especially because there's no pop quizzes or anything like that. So thank you. And for those of you who did not have the chance to read, that's also good to know. And I will make sure that you we don't assume too much knowledge of the case. Now I will ask if you're willing to kind of volunteer to talk through the case with me. Again, no judgment, and there's no wrong. There are right and wrong answers, but all answers are welcome. But if you'd be willing to volunteer to talk through the case, having read it, I won't be cold calling, but just to kind of be on tap as potentially joining in. Could you raise your hands now? And I'm going to wait like the 7-8 awkward seconds as we see who's willing to join in. And I see ERISA, thank you so much. Itan, Alexandra, and you know what I'd like to do for those of you who volunteered, thank you very much. And if we get a fourth, that's great, but if not, that's great. Let's start with just like little brief introductions. So I'll say who I am, and then I'll ask each of you to say a little bit about who you are, which is maybe more than you volunteered for. Maybe I should have warned you in advance, but what's done is done. So again, I'm Matt Lawrence. I study health law, and I did not go into law school focused on health law or even focus on health law when I was there. I was kind of generalist. I just loved learning and wanted to learn about the law. But I wound up really falling in love with health law when I was at the Department of Justice, defending these big healthcare cases and realizing that although kind of obscure and technical, what was happening at the policy legal level in these healthcare cases was really important for tens of thousands of people. It was just hidden. And this ERISA case kind of gets into that. So I wound up becoming very interested in health law. I study health law now as an academic, and that's kind of what brought me to be interested. Can I ask for our panelists, would you each just say, your name, and then either if you have some special interest in health law, love to hear that. If you have some reaction to the case in general, love to hear that, just kind of a quick reaction or anything like that. And can we just kind of go one by one and start with ERISA?
Hi, yes, I have the worst possible name for talking about this case, unfortunately. But my mom actually works at Mayo Clinic, and she's a revenue analyst, so this sort of thing is reasonably close to home. And I also recently got a health insurance license. I ended up not working for that company for very long, but I did study up on all of the health insurance, statutes, and obviously ERISA comes up a lot.
Yeah.
But right now I'm a ghost tour guide, which has nothing to do with health law, but it might be a possible career for me.
I'm sorely tempted to just abandon our plan for the day and just talk ghosts for the remainder of the class, intelligent haunts and repetitive haunts and all that things. But no, we're going to stay on topic. And Itan, and apologies if I'm pronouncing that wrong. Do you mind introducing yourself?
Yeah, no worries. Eitan, yeah. I right now am been living in Houston. I'm kind of in between patent law and transactional law, but I'm really excited to kind of hone in and maybe learn something new, and maybe health law is a thing for me. I don't know. And just a little bit about the court case. This is one of the few court cases that I've actually seen that kind of has like a call to action at the end of the court case, which is pretty rare. And I thought it was really interesting. And, kind of having that, does anyone care at the end of it is pretty powerful.
Yes, you're right. It's pretty, usually judges are they call it the passive virtues. They try to say as little as possible and just talk about the law. And we talk a lot about, the reasons for that. This case is an exception to that, where the judge is deeply concerned and trying to motivate reform. I'll say this case is from, just as a teaser, this case is from 1997. The judge describes what the judge sees as a really problematic situation and calls for reform. And we're here 25 years later and it hasn't happened. And this Judge Young from 1997, Justice Ginsburg, I think Justice Thomas, several justices and judges have all kind of joined this call for reform, but to no avail. Alexandra, how about you?
Hi, my name is Alexandra. I go by Alex. I am currently in New York City right now. I am most interested currently in criminal defense and criminal law, but I'll be honest, labor law and health law are also very near and dear to my heart, as things that I have struggled with and seen friends and like collaborators in my time working also struggle with. So I'm very interested in learning more about that. I think this case was incredibly impactful to read. This is a situation that feels not so much like something that is something that you would only see in like a legal textbook or something, but like a real life situation that I can think of people off the top of my head that have faced maybe not this exact same exemption by ERISA, but a situation where a clear and present need was denied by an insurance company, despite that being something that should have been covered under their benefits. And I think that this is something that, hearing you say that this is a call from a judge that is still 25 years later relatively unaddressed, relatively unanswered, this to me is something that is really, really, really impactful to a lot of people in this country. And I'm really fascinated to talk about it.
That's terrific. Thank you all. Others, please feel free as we go to volunteer, but I appreciate ERISA, Eitan, and Alex being willing to be on the spot. So the awkward silences aren't too awkward for me up here. And that's a great point, and it's a great segue to where I want to start. So you'll hear the term IRAC in law. And when you show up in your first class, wherever you might go to law school, you might well encounter a professor who's going to ask you to walk through something like IRAC. And so what do professors want? IRAC stands for issue, rule, application, and conclusion. And what they mean is, actually, let me say something that's not, but this is kind of fundamental. Before you get to IRAC, you need to kind of know the story of the case. And Alex was just talking about the story of this case, and I want to talk about it in a second, but the story of the case, the way you would tell the story to your cousin who never went to law school, or just to anybody, like what is about, who are the people involved, what's going on? Once you have that kind of factual foundation, that's where a law professor and any given case will have a structure where it will say, okay, that's the story, but what is the legal issue? And lawyers are obsessed with figuring out what is that narrow legal issue? What is the specific legal question we're trying to answer in this case? Once you identify that issue, then the next question is, we're lawyers. We love the rule of law. Whatever the legal issue is, what is the rule? What rule governs the resolution of that issue? And then once you go figure out the rule, whatever it might be, then you apply it to the facts of the case in front of you. Okay, we've got the legal issue. We figured out the rule. We're going to apply it to the story in front of us, to the facts. And that's how we get to our conclusion. And that's a common practice that you're going to see throughout law school that you'll become very familiar with, although it's a little artificial to divide things. So I want to walk through that here. I want to first get the story out, especially for those of you who didn't have the chance to read the case. And then I want to talk about what is the legal issue, what's the rule that governs it, how is it applied, and then what's the conclusion, and then we'll reflect a bit. So let's start though with just the facts. So any of the three volunteers care to just kind of say a little bit more about what's happening in this case, keeping in mind maybe somebody who didn't have the chance to read it and just wants to understand, like, what are the basics of what's happening in this case?
I'll go ahead if that's all right with the other two.
Sounds great. Thanks, ERISA.
Gosh, that's going to get old really fast with the ERISA thing. But yeah, so we have Mrs. Clark, whose husband was an alcoholic, Richard Clark, and he went to the hospital several times for issues related to his alcoholism. And these were 3 different hospitals, as I understand. Now, their insurance does cover a 30-day inpatient program to deal with alcoholism, but the insurance denied doing that every time he went to the hospital, and ultimately complications from his alcoholism seems to have caused him to commit suicide. So Clark, Mrs. Clark is suing, is that suing is the right term?
Yes.
Complaining, suing,
Yep.
For a lot of different things at the same time to try and cover all the bases here. So she's covering breach of contract, which the lawyer in the case was very dramatic. I love the way he says it. He says something about how breach of contract as a matter of something you can go to court for predates the Magna Carta. I love his dramatic flair there, or hers, could be a girl lawyer, who knows. And they also she's trying to sue for wrongful death, of course, and the fact that her husband was not given treatment.
Yep.
So malpractice, of course, comes up. But because of ERISA, this has been preempted. So everything that she could complain about, the insurance company is not liable for because of the ERISA doctrine.
Yeah, terrific. And I'll stop you there as we start to get into the legal side of it. But yeah, that's a great description of the facts. And I'm just going to kind of go back through the timeline just so we're all on the same page. So Diane and Richard Clark have 4 children. Diane Clark has health insurance that the whole family benefits from. And many of you may have a parent who has a health insurance plan that everyone in the family is on the plan. And that's how it is for them. Richard Clark is also on the plan. We're told that Richard Clark drinks to excess, and in April and September of 1994, goes to medical providers, and the medical providers, his doctors, say, you need 30 days of inpatient care. You need 30 days of inpatient rehab care to address your alcohol use disorder. And the way this works is the doctor says you need the care, but the insurer has, who would have to pay for it, has what's called a utilization review provider. And that's a fancy word for the insurer is going to double check that they think the doctor is kind of right. They think that this should be covered. This should be paid for. And what happens is this utilization review provider keeps saying, well, I know the doctor thinks that inpatient 30 days is necessary, but we don't think so. 7 days should be enough. Repeatedly, the insurer says no. Richard Clark winds up having 7 days of care, going home, relapsing. First, he tries to commit suicide after a September discharge in his garage, but the wife intervenes, Diane Clark intervenes and saves his life. He then winds up getting court-ordered treatment. So now you go in front of a judge and you say, this man needs treatment. And the court says, yes, this man needs treatment. Send him inpatient for treatment. But again, the insurer says, we won't pay for it. And because the insurer says we won't pay for it, the court-ordered treatment means he winds up having to go into a carceral setting, into a prison. There in prison, he's raped, receives little treatment, and the judge says that his life spirals inexorably downward. After that, he's released from prison, October 25th, 1994. He spends a night in the emergency room on November 10th. And then he's found dead in his car with a 6-pack of Meisterbrau beer, having committed suicide on November 12th, 1994. And the court really, sometimes there's statistics and it's easy to kind of forget the facts or the real story. And the court here really wants the reader to see the story. And that tees up the issue in the case, which is, can the insurer that kept denying coverage for inpatient rehab care, can the insurer be sued and be liable for some of the damages associated with Richard Clark's death? And that's the issue. And one question I like to focus on right here is, ERISA, Eitan, Alex, or anyone else. Here's the question: does Judge Young, who writes the opinion in this case and comes to the ruling, does Judge Young think that the insurance plan did something wrong and like that it deserves to pay? Do you get a sense of whether Judge Young thinks the insurance plan did something wrong and deserves to pay?
I can take that one. I
Yeah.
would say most definitely yes. However, obviously from ERISA and from reading the case, you can't
Okay, let's stop
authorize.
at the yes.
Okay.
Yeah, but I love it. But
Yeah.
yes. Short answer, correct. Yes. And at page 52 of the opinion, after Judge Young states the facts of the case, he says, "This is ridiculous. The tragic events set forth in Diane Andrew Clark's complaint cry out for relief." And then later on that page, he says, "Under traditional notions of justice, the harms alleged, if true, should entitle Diane Andrews Clark to some legal remedy on behalf of herself and her children against Travelers and Greenspring." So there you have the judge saying his understanding of justice would provide that the insurers should have some kind of liability. And then Eitan, you already hinted at this. So given that Judge Young thinks the plan deserves to pay, does Judge Young rule against Travelers on this legal issue in the case and say that there is some kind of a lawsuit against the insurer?
No, that based off of ERISA, since it protects the you cannot seek remedy or seek suit for wrongful death based off of that. They're covered, and it means that the case has to unfortunately be thrown out.
Yeah, that's right. And and there's a takeaway. There's a broader takeaway here that you're going to see when you start law school again and again. And the takeaway is that lawyers and judges often follow the law for its own sake, regardless what outcome they think would be right or just. And that might seem straightforward, or it actually might seem hard to understand, but it's nonetheless a really important takeaway that you're going to see again and again. Lawyers and judges often follow the law for its own sake, regardless what outcome they think would be right or just. So Judge Young here cares deeply about this. He's upset about it. He thinks the just thing would be for the insurance plan to pay. He's the judge, and he rules for the insurance plan, and he kicks the case out of court. And he says that Diane Andrews Clark has no remedy, none at all. And that's a pretty remarkable thing that reflects that takeaway about judges and lawyers focusing on the law for its own sake. And that's where you get the rack of IRAC. We've got the story of the case. We've got the legal issue, right? How's it going to come out? It's going to depend on the rule and then the application of that rule to the facts of a case in front of us. And we've already hinted at it before, but the rule here is coming from this federal statute called ERISA. And this, if you're looking at the case, comes at page 57. And I'm flagging this page 57, and I'll give a hint that in a minute, I'm going to ask if anyone can kind of spot the legal rule as it's articulated there around 57. But let me give like kind of a bit of background here. In the United States system, we have a federal system, which means, as I think we're all familiar, we actually have two sovereigns, two kings that govern us. We have states and we have the federal government. And it's the kind of one of the genius points of our Constitution is if we have two different sovereigns, we're actually more protected from tyranny than if we just had one sovereign, even though there's two different entities that can tell us what to do and make rules for us. And that's the federal system. And the kind of default in the federal system is that states can regulate. They can regulate breach of contract. They can regulate insurance, things like that. And it's under that default that Andrews Clark tries to sue. Go to court, bring a kind of a typical state tort claim, contract claim, seek damages through state law. And normally that would be fine. But there's two sovereigns, and the Constitution says the federal government, when it regulates on a subject, trumps state law. So where the federal government can regulate, it can push out state law, which is a pretty remarkable thing. And this is often called preemption. The federal law on the books preempts the state law, makes it inapplicable. And that's the exact kind of structure that we get with the ERISA statute. This is a federal statute that was passed to regulate employment plans, employee benefit plans, retirement plans, pensions, and also health insurance. And ERISA includes a preemption provision that basically says, this is the federal rules that we're setting in the ERISA statute. Those state rules, they're off. They're out. You can't use them in a certain domain. And that's where the rule here comes in. So before I go to the rule, any questions about that kind of preemption concept? Feel free in the chat or anywhere else to throw in a question. I'm not seeing any, so I'll move on.
Sorry, I did
go.
actually have a question about that.
Yeah.
My only legal knowledge comes from like the essays that we read in the LSAT, so this might not be true, but it was my understanding that while the UK and a lot of other legal systems are very focused on the exact letter of the law, that the US tries to focus on the spirit of the law. And given that ERISA was designed to protect consumers and employees that have insurance, it doesn't make sense for the judge to rule with just the letter, like you said, the law at hand.
Yeah. Arisa, your question is great. And I think I'll be better able to answer it in like 3 minutes once we get the letter here down. So I want to come back to it in just a second. I really appreciate it, especially because Emory is one of, it's maybe about a third of schools that teach legislation and regulation in the 1L year. Everyone takes it. And that is a class where you learn about interpreting statutes. And do we follow the letter of the law or the purpose? And we also learn about administrative regulations and how the administrative state works. And I teach LegReg, that class, for fall 1Ls. So I love this stuff and we spend a lot of time on it. So let me come back to it in just a moment. But for now, I just kind of explained, the federal statute preempts state laws. This means that the question, can Clark sue, actually becomes a question of, is her suit preempted by ERISA? So then the question is, well, what does ERISA preempt? What is the rule for ERISA preemption? And there I'm curious if anybody's been able to look around at page 57 and try to come up with some sense of what the rule is. Don't worry about if you think you're right. And I'll give it the 6 awkward seconds and then jump in. Okay, so when you're in a law school class and you're doing IRAC, it's like issue, rule, application, conclusion. Oh, Nicole, I saw your hand jump up and then go away. So if you want to dive into the breach.
Okay, I'm not sure, this might be completely wrong, but the part where I think that ERISA supersedes is in the footnote where it says ERISA shall supersede any and all state laws insofar as they may now or hereafter relate to any employee benefit plan. And then they have a whole conversation in the footnotes about the problems with the words relate to.
Yeah. Yes, the ERISA rule is relate to. That's perfect. And it is mentioned above the line a couple of times. Let me just say, like, I really appreciate your jumping in, Nicole. And when you're in a law school class and the professor asks, like, what's the rule? It's really worthwhile to just, as Nicole did, just try to figure out what you think the rule is. And at first, you're going to be wrong. You're not going to have gotten the same rule the professor will say. But over time, you're going to get good at reading a 20-page opinion and picking out one sentence. And you're going to say the rule is the words in that sentence. And the law professor is going to say the same thing, and you're going to feel a lot of confidence about yourself as a lawyer as that starts to develop, your ability to kind of derive a rule from a case. So yeah, here, the rule comes from the statute because it's federal preemption, it's come from the statute. So we look to the statute, and that's in the US code, and it's passed by the federal government, or by Congress. And here the statute says that it preempts state laws that, quote, relate to an employee benefit plan, like a health insurance plan. And so you might then ask, okay, we've identified the words of the rule relate to, but what good is that? Like, what does relate to mean? Everything relates to everything in some sense. And so then we get at 57, this is true of how ERISA precedent works. The Supreme Court has explained that you can tell if something relates to an employee benefit plan by asking whether or not the thing has a connection with an employee benefit plan. So the rule, I guess the Supreme Court thinks that the rule that preemption applies if something relates to an employee benefit plan, that's too unclear. So they clarified everything by saying preemption applies if it has a connection with. an employee benefit plan. And if I seem a little salty about this, it's because I clerked right after law school in the DC circuit, and we got an ERISA preemption case. And I, as the clerk, had to like make a recommendation for my judge about how to apply ERISA in some case. And neither relates to nor connection with really tells the judge what they're supposed to do, right? Or at least they seem to apply to everything. I've complained about the rule, but if you're taking notes for your future ERISA class, the rule here is that ERISA preempts statutes, lawsuits that relate to employee benefit plans, which means have a connection with. So we've got that legal issue. Can she sue, which is really, does ERISA preempt the lawsuit? And then we've got the rule, ERISA preempts the case if it relates to the underlying employee benefits plan. And then we have to apply the rule. And the application stage goes from the law in the books to the facts in front of us. And so the court then has to apply the rule, and it applies it at 58. And it's in the application that the distinction that ERISA made earlier comes out. I'll save the volunteers and I'll just say, what the court says is, Clark's suit challenges the way the insurer decides which claims to pay. Does the suit that challenges the way the insurer decides which claims to pay connect with or relate to the plan? Well, those words are very broad, but perhaps you could narrow those broad text words with the purpose of the statute, right? So maybe there's an out. If, like ERISA was saying, we say, instead of looking at the text of the statute, let's look at its purpose. And you might say, well, maybe the purpose of the statute is to protect employees, and so it doesn't apply or something like that. But unfortunately, when you're trying to figure out what the purpose of a statute is, you also have to go to the underlying statute and figure out what was the actual purpose of Congress. And I say that's unfortunately for Clark, because here the underlying purpose is uniformity in plan administration. So the court looks to the precedents, they look to, why did Congress pass the ERISA statute? Why would Congress say, here are the rules for employee benefit plans, and preempt state laws? And the answer is that Congress wanted uniformity for insurance plans and for employee plans. And what does that mean? Picture if you go to law school, you graduate, you become general counsel at Walmart, right? Thanks to ERISA, when you're devising your employee benefit plan, you don't have to go do a 50-state search and figure out what is the contract and tort law in Georgia, in New York, in California, in Indiana. You don't have to figure it out in every state because ERISA has preempted all the state laws. You just have to figure out ERISA. And so there's this big uniformity benefit to you. It makes it easier for you to design plans, to administer them on a nationwide basis. It has these kind of uniformity benefits. And that anyway was the intent, the purpose of this ERISA preemption provision, or it seems to have been. And so what the court says is, when we apply this rule, ERISA preempts if it has a connection with or relates to, even the purpose supports concluding that the suits by Clark are preempted, because what would happen if you could sue for tort for claims administration in Massachusetts? Well, then you'd have to have different claims administration rules in Massachusetts and New York and Indiana and California. It would defeat the uniformity goals. And so when the court comes to apply here, the statute, it concludes that whether you go by the letter of the law, by the text, by the words, which are very broad and say relate to, or you go by the purpose of the law, the spirit, which is uniformity in plan administration, whichever one you do, Clark can't sue, case is preempted, there's no cause of action in state court. And so bottom line is case closed and case dismissed, not able to proceed. I want to reflect on that a bit, but first I want to highlight a takeaway there. So I don't think you're going to take away from today the specifics of ERISA preemption and these words relate to blah, 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 blah. But if you can abstract from that, I would like you to take away how the court looked to the text of the statute. It looked to Supreme Court precedent interpreting the statute. And then it also looked to the purpose of the statute. And if you can already begin to divide those three things about statutes in your mind, the text, precedents from courts interpreting it and the purpose, you'll be kind of well served as you go to read cases in the fall and you start law school. So that's that's the takeaway from that, not the specifics of ERISA preemption. But now let's actually just step back for a second. We've done the law, IRAC, we've gone through the case, but part of being a lawyer and part of the goals of law, it's not just to know what the law is today. Often it is to find ways to change the law in order to change the world, right? So the dream is, or the goal is, that if we can figure out a law that contributed to the death of Richard Clark, that we could change the law and thereby actually change the world in a way where he winds up getting treatment and maybe getting into recovery and not dying. I mean, that's motivating a lot of time and energy that goes into studying law. So that pushes on us the question, what change would you make here? Like, how would you change this law? And let's start, I'll ask again, my panel or anyone else. Judge Young has a sense of how we should change the law here in order to try to avoid Richard Clark's death or deaths of future cases like that. So my question is, who does Judge Young think is to blame for Richard Clark's death?
I
Any
believe
volunteers?
it,
And maybe I saw Fred raised his hand. So Fred, do you want to jump in?
Sure. My thought would be that initially it would be kind of like not direct blame, but initial blame would fall on that insurance company for intentionally reducing from 28 days to 7, and then being like, I don't want to pay, just go to prison. That's a fine place to get treatment. And then secondarily, the legislators and those who would have written the laws to work in this manner.
Yeah, you all are good. Your answers have been great so far today. That's exactly right. Judge Young he blames the insurance company, but then Judge Young's a lawyer and he knows the insurance company is just responding to the incentives given it by the law. So really Judge Young blames the law, which means he blames Congress for not changing the law. And that's his bottom line. And this is where you get to the very end of the opinion, where he says, although the alleged conduct of Travelers and Greenspring in this case is extraordinarily troubling, even more disturbing to this court is the failure of Congress to amend a statute that, due to the changing realities of the modern healthcare system, has gone conspicuously awry from its original intent. Does anyone care? Do you? And I've probably, I've taught this case at least, I don't know, half a dozen times or something, and I still get chills reading through that paragraph. Judge Young he has a clear sense of who's to blame, and it's the insurer, but then it is Congress, and he thinks that Congress ought to act to change ERISA preemption. Something we also have to do as lawyers is evaluate whether changes in the law, what they would do. And so Judge Young thinks that if we gave liability to insurers in a case like this, if the insurers had to pay, that would prevent deaths like Richard Clark's, and it would generally be a good thing. And let's play kind of devil's advocate for a minute, or let's kind of look under the hood of that thought, because certainly it has some intuitive appeal. But let's just dig in a little bit. And I have a few questions to the panel or to volunteers. The first is, when an insurance plan denies coverage for rehabilitation care or anything, when an insurance plan denies coverage, they could potentially be held liable in court for damages. Who do you think would sue? Would everyone sue who was wrongfully denied? Would only certain people wind up suing? Would it be kind of a random sample of society who would wind up suing? Who do you think would wind up suing and getting the benefit of that damages provision? And I see yeah, I can't see full names on my little participations list. I see name starts with AL. I'm really sorry about that.
I think that's me.
Oh, yeah. Alex, go ahead.
So I think that if we were to open up the ability to take insurance companies for court for failure to pay out something that was guaranteed in a insurance plan, the only people who would be able to take advantage of litigation in that way are people that have the disposable income to hire a lawyer. Going to court is incredibly expensive and cost prohibitive for the majority of people. Even if that healthcare that was denied to them did severely impact their life or their ability to work, if you don't have the income or the available cash to hire a lawyer and fight this out in court for an extended period of time, it doesn't matter if you have the ability to take someone to court, you still can't do it.
Yeah. And ERISA, were your thoughts along those lines? I saw your hand up too.
Yeah, they were. But I would add that, I mean, lawyers do pro bono work for a reason. A lot of, I guess, would you say tort lawyers in this case would work on contingency? So when it's something like this, hopefully you can find somebody that'll work on contingency. But not everybody knows that, you know, so people just think lawyer equals expensive and they don't even think to try. It's the learned helplessness.
Yeah. So great answers, which get at, there's some uncertainty here about who would sue. And it's certainly very possible, and I do a lot of work with like mental health coverage denials and insurance. If a person denied coverage for addiction treatment is not in a great position to pursue their legal remedies, right? So the people who are most likely to wind up being in a position to sue are people who have lawyers in the family, who have a lot of wealth already, who are getting pretty good treatment as it is. You're not going to get a random sample society. You're going to get a sample that kind of aligns with already inequitable distributions of privilege. This is an empirical question we'd have to dig into. And I agree with ERISA that the more maybe pro bono work, the more maybe contingency fee work, maybe you could get a different distribution. But just one point is the lawsuit remedy may have kind of inequitable access that comes with it. And Nicole, I see a hand. I don't want to dominate the stage if you have additional thoughts too.
I was just going to ask the question, does it really matter who would sue? Because the very fact that the insurance agencies could be sued would open them up to the potential liability. And so they would be less likely to wrongfully deny coverage, just because like that's the job of the market to fix this problem if the law, you know, is on the side of the person who's wrongfully denied coverage.
Yeah, I'll say that the dream would be that regardless who sued, the insurer would be so afraid of getting liability that they would kind of have better practices. The fear would be that the insurer would be able to kind of know that only certain categories of claimants might well sue. And so would, let's say, you know, have more cautious policies when it comes to a hospital with mostly private pay plaintiffs, but with mostly indigent plaintiffs clinic or something, a Medicaid managed care plan or something might approach it differently. I don't want to get, these are great, and I see additional hands. We are speculating right now about who would sue. I just am trying to introduce, there's this equity kind of who benefits dimension to the lawsuit question that is worth thinking about. Another question I would flag is, let's say the insurer does have liability, and let's say everybody sues. How does the insurer respond to that liability? What does the insurer do? Any thoughts?
They might overcorrect.
And what do you mean by that?
They might send everybody to inpatient treatment mandatorily.
What's so bad about that? If it's not mandatory, but if they cover anything that anybody wants.
Can I take that real quick?
Yeah.
What happens to your healthcare system? What happens? Just thinking about it publicly. That's the thing with public policy, right? There's always a winner. There's always a loser. So it could be exorbitant lines. It could be no access based off of a first come first serve basis.
Yeah. Any other thoughts, Alex? Or Nicole, I see your hand actually.
Yeah, can you hear me?
Yeah.
Yeah, well, healthcare costs are just going to go even further through the roof because they're going to approve all the care that people want. And then if they end up having to pay out a lot of claims in court for the times when they didn't, they're going to transfer those costs to those people insured.
Yeah, and Jillian, I saw your hand pop up and then go down, so I'm wondering if you were thinking healthcare costs as well. So yes, and so the more the insurance plan covers and the more liability it faces, the insurance plan has to bring in enough through premiums every month that people who participate pay to pay for the claims that it pays out. And so what the insurer would say is that if we have liability, we are going to have to raise our premiums, which means that insurance, instead of costing $400 a month, is going to cost $450 a month or something like that. And they would say what that's going to do is actually price out of insurance people who can't afford those premiums. So you will be trading, is what the insurer would argue. You'll be trading coverage for the Richard Clarks and maybe other cases like that. You'll get it, but you will lose all insurance for people who can't afford the increased premiums. And that's the sort of argument they would make. Well, I'm not here today to resolve these arguments, but what you start to see is that the tool of litigation and liability after the fact has certain pros and cons as a way to correct what we're concerned about, which is wrongful denials of coverage. And one of the things we do as lawyers is we learn about different tools for changing the world, different ways to use the law. So instead of litigation, we could change the way insurers are reimbursed. And I study this, it's called risk adjustment, so that they get kind of a reimbursement bonus for caring for people with chronic illnesses, and they might not have the same incentives to deny coverage in the first place. Another option might be audits, where maybe a state or a federal agency comes in and audits all of their decision making and polices that way without courts coming in and without liability. Just examples of different kind of regulatory tools. And then I want to get to an even broader point, but first, Jillian, I see your hand up. So thoughts?
Yes, apologies. I'm on a cell phone today, which is a new Zoom format for me, so I wasn't sure how to speak.
No
but
problem.
Very similar to what Nicole had said about if insurers are concerned about liability, that may lead them to over approve of certain things. And I was thinking that that's very similar to the concept on the insurer side or on the practitioner side of defensive medicine and over prescribing, over testing, and that ultimately increasing the healthcare costs, like we were saying.
Yeah. Great point. And when you take torts, and that is something that comes up with medical malpractice, is defensive medicine. So now let's say we're getting frustrated with the idea of imposing liability on insurers. Originally, it seemed like a clear case. Maybe you think it still seems like a clear case. But now let's say, well, let's look, maybe there's someplace else the law could intervene to try to address this. So now here's my kind of question for the panel or any of you. If you can't blame the insurer and you can't blame ERISA, who else could you blame for Richard Clark's death? If you go through the facts and what happened, anyone else you could potentially try to blame? I've got at least, I think, 3 or 4 entities, people, concepts, cultural norms that we might try to blame. I see Robin and Nicole.
He could blame the prison system because that put him at risk, and he was assaulted while in prison getting treatment.
Yeah, absolutely. You could blame the prison system where you went to prison and he was raped in prison. And that seems like a target for blame. Who was next up? Sorry, I lost track.
I was going to say you could blame the first rehab center that he went to where he was discharged after 8 days, because what did they do in 8 days? Doesn't look like they helped very much.
Yeah, and you could blame the physicians. In fact, there's a note here that the physicians were sued and dropped out of this particular case, but you could blame the individual physicians. Other thoughts? Eitan.
Even though I don't necessarily agree with it, I think you can actually blame Diane herself, because I think she left him out after coming back from prison and left him to his own devices.
I'm sure that in health law, we often encounter situations where the system fails somebody And because the system fails the person, it's left on family members to try to come through for them. This happens a lot with elder care, where we don't have a good system for long-term care for people who are aging. Family members try to come in and help, but then the family member winds up feeling a lot of blame or guilt about their kind of places where they don't succeed or something like that. And you could have the same sort of thing here. Other thoughts of places to blame?
If we wanted to be really cynical, we could blame himself for choosing to buy alcohol. Obviously, that wasn't at issue in the case. Nobody was arguing that that it was anything other than a health care issue.
Yeah.
But I could see an insurance company making that argument that this is a self-inflicted wound of sorts.
If you right now, the state of Georgia is considering legislation to be more protective when it comes to health insurance coverage of substance use disorder and mental health claims. And if you want to understand the dynamics of that kind of a legislative fight, you need to understand that some people are going to blame the individual, and there's going to be a personal responsibility narrative. And I see other hands up, but I don't know if they're left over from before. Robin, Nicole, and Jillian. And we've got a kind of lightning round because I realize we have 9 minutes left. So others to blame. I have at least 2 more, I think.
The hospital in New Hampshire that discharged him without recommending any detoxification treatments.
Yep. And Robin?
Sorry, I think I forgot to put my hand down from
No
last
worries.
time.
And let me run. So, yeah, these are all great. And let me add a couple more. Since I study public health, sometimes public health often focuses upstream. So downstream is the person who gets sick and their interactions with the healthcare system. And upstream is what are the determinants of how they came to get sick. Maybe they live in a neighborhood with really bad air quality or something like that. So with that in mind, Meisterbrow Beer, who sells the beer, could potentially come under the blame list. I'm not saying any of these should be blamed, but if we're trying to figure out potential leverage points. Societal stigma surrounding mental health and addiction treatment. We don't know how long Richard Clark was dealing with alcoholism. We don't know if he had comorbidities like other mental health issues that were going untreated, but we do across our country have just under treatment of mental health, and it's largely connected to stigma around that. And so if we're looking for a place to blame, that might be one. Early childhood events. So in the public health field, we get into upbringing and things like that that can be determinants. These would all be potential places to blame. Okay, again, we're not trying to figure out who should necessarily be blamed, but I have a takeaway here. And this takeaway is going to also influence any case you encounter in law school. The way someone sees a problem often defines the solutions they think about. So if you see this as a problem of insurance coverage, you think about insurance solutions. And if you see this as a problem about stigma, you think about combating stigma. And if you think about prisons, you think about fixing prisons. So the way you see a problem often defines solutions. And relatedly, the way you think about a problem is often a function of the perspective that you take. If you take the perspective of the insurer, you think about certain things. If you take the perspective of Clark battling alcoholism, you take the perspective of other things. And so one of the tools of the lawyer is perspective shifting, being able to see the perspectives of the different entities, different players involved, in order to think not only of kind of solutions, but arguments and how they're going to see the world, maybe to make your most persuasive case, or maybe to come up with ways to navigate a legal problem that others would not see. I have a very kind of quick little story about that. I litigated when I was at the Department of Justice. And so people would sue the federal government about some regulation or something they thought was unlawful, and I would defend it. And I remember being on, I was in the car on the way to Rhode Island for a vacation, and I checked my phone email, and there was a lawsuit that had come in from an insurance company in Maryland that said that a certain federal healthcare program was going to, it was an Affordable Care Act program that they said was going to put them out of business, and it was unlawful. And they were seeking emergency relief, and there was going to be a hearing the next week, and we had to write briefs right away and everything. And so I remember actually, I think my wife was then forced to drive the car while I did research in the shotgun seat, and we put together the briefs, and we went down there to court. And our arguments were that this healthcare program, so the government's arguments were that this healthcare program, which is imposing costs on this insurance company, that it has these benefits across the system because the program combats insurers' incentives to discriminate against sick people, like by denying rehab care. And I won't go into details of that, but our argument was this kind of very structural incentives kind of argument. The insurer's argument was that the program was going to put them out of business. And when we get to court, the insurer has the CEO up on the stand. And they ask the CEO, what will happen if you lose the lawsuit? And the CEO points at the back of the courtroom and says, all our employees will be fired, and they're all back there. And this was brilliant lawyering by the plaintiffs, forcing on the judge the perspective of the insurer, the perspective of those people who are going to be fired, and emphasizing all those kinds of aspects of the case. And meanwhile, then when it's my turn, I'm up there talking about economic principles and incentives based on the reimbursement policy and just doing my best to connect those abstract kind of policy considerations to the kind of personal experience of, as I was doing it, a person with diabetes or with substance use disorder who's trying to get coverage. It was very, very hard to do. I'm not sure we completely did it, although we won the case. That's maybe a story for another day. But I kind of tell that story as an example of the importance of seeing different perspectives. And then that underlying point that the way the person you're trying to persuade, the way the court, maybe even the way the professor sees the issues is often determinative of kind of solutions they come to. So that's my last takeaway here with 4 minutes left, is kind of wherever you go to law school, whatever classes you take, and whatever you want to do as a lawyer, thinking a lawyer, you have to be analytical and pick apart problems, but you also need to see the different perspectives of the parties involved and be able to shift among them, which can be a very kind of hard thing to do. And it's a skill that sometimes it takes time to develop. So that's my kind of last takeaway from this ERISA case. But I have to say how much fun it's been to go through it and how great you've all been with your participation. And my regret is that we have only 3 minutes left. I would love to answer any questions you have about law school in general or Emory's healthcare programming or anything like that in our 3.5 remaining minutes. But I do. But thank you again. This has been really terrific and fun.
Yeah. And Professor, I think if you have 5 minutes, maybe we can stay on and answer, let's say 3 questions from the audience here, just generally about Emory or law school. So if you
I'd
have
be happy
question,
to.
Yeah, excellent. So if you have a question, let's just continue to practice. You can raise your hand and we'll get you in front of the professor here to ask questions. It could be anything about the school, about healthcare, about Atlanta, any questions generally you have about law school. I think we can stay on for a few minutes and answer 3 of those questions. All right, let's see. Let's get Fred. Looks like Fred, you were the first one to get your hand up. So Fred, you got a question for us?
So I was going to ask, in your classes, do you have like any cases that specifically like the kind of case you're waiting the whole semester to teach your students about? You're like, a favorite case that really shapes how your students view the material and the class as a whole? Thank you.
Yeah, that's a really fun question. So this case that I assigned today is actually a case I really love because of how it connects the policy to the personal and it forces different perspectives. There's a case we teach in legislation and regulation called Chevron. And basically the first 9 weeks of that case are a build up to that. Sorry, the first 9 weeks of LegReg, in a way, all build up to Chevron and how it works. But if I can give you the short version of it, it is statutory interpretation is normally something courts do. But Chevron creates situations where when it's unclear what the law is, courts don't decide what the law is. Administrative agencies do, like the Department of Labor or HHS or something like that. So it really shifts power in the federal system, at least from courts as the ones who decide cases to agencies, which is just a neat thing. It's a fun case to teach, and it reveals something that's so important about law practice today, which is that law comes not just from courts, not just from legislatures, but from a lot of other types of actors, especially administrative agencies. And so understanding that side of things is so important. Okay, and I could go on, but great question.
Excellent. Thanks, Fred, and thanks for participating today as well.
Thank you.
Looks like we had one quick question in the Q&A from ERISA as well. Professor, would you mind going over what IRAC stands for again?
Yeah. So IRAC stands for issue, which means the legal issue in the case. Rule, which means what is the legal rule that governs resolution of that issue. Application, which means how do we apply that rule to the case in front of us. And then conclusion, given our application of the rule, how do we come out? And it's a kind of a common conceptual framework for digging into a case. So that's what IRAC stands for.
Excellent. Do we have one final question? If not, we can wrap up. Okay. Well, I think we'll go ahead and wrap up then. Oh wait, here we go. Let's get Robin up. All right, Robin, you got our final question for this afternoon.
All right, awesome, thank you. This is actually about the case. I noticed that we talked about how the ERISA rule applies to employers, and how cases or how healthcare is administered for the employee benefits. But right now we have the Affordable Care Act, and a lot of people are buying directly from the exchange. How do you think that this kind of rule would be applied in that case, or could it be?
Yeah. Our healthcare system is very fragmented. So about 50% of people get employee plans, and that's going to be covered by something like ERISA. But you're right that I think it's maybe 9% or so get their plans through the Affordable Care Act. And then, of course, there's Medicare and Medicaid. The rules governing when a plan can deny coverage for an ACA plan are more strict than with an ERISA plan. So the rules are, in a sense, kind of more protective of patients for Affordable Care Act plans. And there's different provisions of the Affordable Care Act that try to do that. But actually, interesting, your question is insightful because the Affordable Care Act does not provide for liability for insurers either. It does other things to try to prevent wrongful denials of coverage, but liability is not one of them. I definitely have colleagues who would argue that there are major problems with ERISA for clearing state law, but that the answer to those problems is not necessarily liability for insurers, but other types of reforms, like those that we have in the Affordable Care Act and Medicare for Medicare Advantage insurers. And I have an article, by the way, just as an aside, if you're curious about these issues, I have an article. It's called, the title includes the words "parity is not enough." And I put an exclamation point in it, which is my nod to Judge Young. And if he's willing to go out there in an opinion, I'm willing to go out there in a title. And it addresses some of these issues. So anyway, if you're curious to learn more about these specifics, rather than some of you may be running away from health law and never looking back, but for those who are curious, I love it.
Thank you.
Excellent. Well, thank you, Robin, for that final question. And thank you, Professor, so much for taking an hour, taking time on your lunch to join us and talk through this case. I hope those of you that joined it found it insightful. You got a little bit of kind of insight into what law school is going to look like, and learned a few tips and trades that'll help you during your 1L year. That'll get you to ahead of the class here at Emory. So thank you all so much for joining. Again, a special thank you to the professor for all of this information. Again, hopefully we'll see you this evening at 7 p.m. for our California alumni session. If not, we'll have our wrap-up events next week and our big Admitted Student Day in person. So hopefully we'll see you all around. Thank you all again so much. If you have any questions after today, please email me directly. Happy to answer questions and make any connections here at the law school. So thank you all so much. Professor, any final departing words?
Just appreciation for you all taking an hour of your Fridays to talk about ERISA in an ungraded, purely optional format. So I really appreciate it, and thanks so much.
Great. Well, thanks everyone. Welcome to Emory, and we look forward to seeing you in the fall, and hope everybody has a great weekend. See ya.